We got some breaking news coming out of Judge Chutkan's chambers. She has a new order in the District Court of D.C. against Trump administration and the DOGE. Remember DOGE, the Department of Government Efficiency, that was busy mass laying off federal workers, cutting funding, putting agencies out of business, terminating grants, cutting off congressionally approved funding. Remember that group?
Welcome to Dr. John Podcast. Stop whatever you're doing right now, because we just got breaking news. Judge Chutkan just issued a ruling that changes everything about DOGE. The deliberately opaque operation that was mass firing federal workers, gutting agencies, and canceling congressionally approved funding with almost zero accountability. Well, Judge Chutkan just issued a new order, and it is devastating for the administration.
To further combat inflation, we will not only be reducing the cost of energy, but will be ending the flagrant waste of taxpayer dollars. And to that end, I have created the brand new Department of Government Efficiency, DOGE. Perhaps you've heard of it. Perhaps.
The lawsuit brought by a coalition of states and nonprofits against DOGE is moving forward, and the legal theories that will now be tested in court go straight to the constitutional heart of whether everything DOGE did was illegal from the very beginning. This is the case Trump feared most, not the classified documents case. Not the election interference case, this one. Because this one doesn't just challenge a single action or a specific policy.
Which is headed by Elon Musk, who is in the gallery tonight. Thank you, Elon. He's working very hard. He didn't need this. He didn't need this. Thank you very much. We appreciate it. Everybody here, even this side, appreciates it, I believe. They just don't want to admit that. Just listen to some of the appalling waste we have already identified. $22 billion from HHS to provide free housing and cars for illegal aliens. $45 million for diversity, equity, and inclusion scholarships in Burma. $40 million to improve the social and economic inclusion of sedentary migrants. Nobody knows what that is.
Large lot. Well, let me say perhaps a few words that this is not the end of DOGE, but really the beginning. My time as a special government employee necessarily had to end. It was a limited time thing. It's 134 days, I believe, which ends in a few days. So that it comes with a time limit. But the DOGE team will only grow stronger over time. The DOGE influence will only grow stronger. It's I liken it to sort of Buddhism. It's like a way of life.
This one challenges the entire architecture of how DOGE operated. And if the plaintiffs win, everything DOGE touched, every firing, every funding cut, every agency shutdown, could be invalidated, completely wiped out. Let me walk you through exactly what Judge Chutkan just ruled, why it matters so much, and what comes next, because this is going to get very interesting very quickly. So here's what this case is actually about. DOGE was created as this massive government efficiency operation with sweeping powers. It was laying off federal workers by the thousands. It was cutting off funding that Congress had approved. It was terminating grants that were supposed to go to states and nonprofits. It was effectively running large parts of the federal government without any real oversight. And here's the problem. The person running DOGE, whether it was Elon Musk initially or whoever took over after him, was wielding so much executive power that under the Constitution, that person should have been confirmed by the Senate. The Appointments Clause of the Constitution is very clear about this. If you're exercising significant authority on behalf of the federal government, you need to go through the confirmation process. That's part of the checks and balances system. That's part of what prevents a president from just putting whoever he wants in positions of enormous power without any congressional oversight. But DOGE was created and run by people who never saw a Senate confirmation hearing, never faced a single question from a senator, never had to explain their qualifications or their plans. They were just put in place and given the keys to the federal government. The lawsuit that was filed by a group of states and nonprofits argued that this violated the Appointments Clause. They also argued that even if you set aside the appointments issue, the things DOGE was doing were so far outside any authority they could possibly have been given that they were what lawyers call ultra vires, literally meaning beyond the powers. And when a government official acts beyond the powers they've been given, their actions can be invalidated regardless of how they were appointed. The Department of Justice, representing the Trump administration, filed a motion to dismiss. They argued that the lawsuit had no legal basis, that the claims shouldn't be allowed to proceed, that the whole thing should be thrown out. That's standard procedure. You get sued, you file a motion to dismiss, you try to kill the case before it really gets started. Judge Chutkan just issued her ruling on that motion, and she kept the heart of the case alive. Let me break down exactly what she decided. There were multiple claims in the lawsuit. She dismissed some of them. The Administrative Procedure Act claim, a separation of powers claim. Those are gone. But the two claims that go to the constitutional core of DOGE's operation, those are moving forward. First, the Appointments Clause claim. This is the argument that the person running DOGE was exercising such significant executive authority that they needed Senate confirmation. Judge Chutkan looked at the allegations and said, yes, this is a plausible claim. The plaintiffs have pointed to public statements by the president, by DOGE officials, by other administrative officials that support their allegations that DOGE had seized an expansive role in the federal government. This wasn't some minor advisory position. This was someone making real decisions with real consequences. And if that's true, then the Appointments Clause applies. Second, the ultra vires claim. This is the argument that even if you somehow resolve the appointments issue, the things DOGE was doing were so far outside any authority they could have been given that they were illegal regardless. Judge Chutkan specifically addressed the government's argument that the plaintiffs failed to identify a specific statute that was violated, and her response is important. She said that conduct in violation of specific statutory limitations is just one example of an ultra vires act, not the only example. You don't need to point to a specific law that says DOGE cannot do this if what they're doing is so clearly outside the scope of what they were authorized to do. The plaintiffs have plausibly alleged that DOGE officials were ordering agency officials to terminate grants and cut spending without any authority to do so. That's enough to keep the claim alive. And then there's a passage in the ruling that I want to read you because it shows exactly how seriously Judge Chutkan is taking this. She quotes Justice Clarence Thomas from a concurrence in Trump versus United States. Listen to this. The court will not countenance such a two-front attack on Congress's role in our system of checks and balances. If Congress has not reached the consensus that a particular office should exist, the executive lacks the power to unilaterally create and then fill that office. Indeed, if the president unilaterally creates a principal office, endows it with unlawful powers, and fills it without Senate confirmation, that is more, not less, reason for Appointments Clause scrutiny. That's a conservative justice's words being used to justify letting this case proceed. That's significant because it means this isn't some liberal judge making a partisan ruling. This is basic constitutional law. The executive branch cannot just invent offices, give them enormous power, and fill them without Senate confirmation. That's not how the system works. Now, you might be thinking, wait a minute, didn't we just see something like this happen? Yes. Literally, in the last week, a federal judge named Royce Lamberth ruled on a very similar case involving Carrie Lake. She was put in charge of Voice of America, the government-funded international broadcasting agency. Same issue. She was exercising significant executive authority without Senate confirmation. Judge Lamberth ruled that everything she did in that role was illegal and improper. Same constitutional principle, different agency, same result. So Judge Chutkan is not operating in a vacuum here. There's a growing body of case law that says you cannot do what the administration tried to do with DOGE. You cannot put someone in a position of that much power without going through the confirmation process. And if you do, everything they did can be invalidated. Let me put this in context for you. I've been practicing law for 35 years as a litigator. I've seen motions to dismiss from every possible angle. I've won some, I've lost some. I've seen judges dismiss dismiss entire cases. I've seen them keep cases alive on the thinnest of threads. What Judge Chutkan just did here is not a thin thread. She kept the constitutional core of this case alive. The Appointments Clause claim is going forward. The ultra vires claim is going forward. That means this case is going to proceed to discovery. And discovery is where things get really interesting. Let me tell you what happens next, because this is where the entertainment value of this case goes through the roof. The case moves into the discovery phase. That means depositions. That means document exchanges. That means sworn testimony. And at the center of all that is going to be Elon Musk. Because even though he stepped away from DOGE at some point, the entire operation was built around him. He was the face of it. He was the one making public statements about terminating contracts and shutting down agencies. He was the one bragging about what DOGE was doing. And now he's going to have to sit for a deposition under oath with lawyers asking him questions about exactly what power he had, exactly what decisions he made, exactly who told him he could do what he did. I can't wait for this. I've prepared high net worth individuals for depositions. I've seen how they handle being put under oath and asked tough questions by skilled litigators. Here's the pattern. They're not great at it. They don't prepare well because they think they're smarter than everyone in the room. They get combative because they're not used to anyone challenging them. They come off as arrogant and out of touch because they literally cannot relate to how normal people perceive them. And juries and judges hate that. They see someone who thinks the rules don't apply to them, and they want to make sure the rules apply to them very, very hard. Elon Musk just gave testimony earlier this week in a securities case about taking over Twitter and renaming it X. He lost billions of dollars. That testimony did not go well for him. And now he's going to have to do it again in a case where the stakes are even higher. Not just money, the constitutional authority of an entire arm of the federal government. And it's not just Musk. There will be depositions of other DOGE officials. There will be document productions. There will be fights over privilege claims and what the administration has to turn over. This is going to be a slog, but it's a slog that the administration did not want. This is the case they tried to kill with a motion to dismiss. And Judge Chutkan said no. If the plaintiffs prevail on the Appointments Clause claim, everything DOGE did could be invalidated. Every firing, every funding cut, every grant termination, every agency shutdown, all of it could be undone because the person doing it didn't have the authority to be in that position in the first place. That's not a small thing. That's not a minor legal technicality. That's a wrecking ball hitting the wrecking ball. If the plaintiffs prevail on the ultra-vires claim, the same result. Even if the appointments issue somehow gets resolved, if the court finds that DOGE was acting beyond any authority it could have been given, all of those actions get invalidated anyway. So there are two independent paths to the same outcome. Either one could bring down everything DOGE did. This case is being heard by Judge Chutkan. You remember Judge Chutkan? She was the judge presiding over the DC election interference case against Trump. If Trump has a favorite judge, it's Judge Cannon in Florida. If he has a least favorite judge, it's Judge Chutkan. She is not someone who is easily intimidated. She is not someone who bends to political pressure. She is someone who runs her courtroom with precision and expects the government to follow the law. And right now she is looking at a situation where the government created an entire office, gave it enormous power, filled it with people who were never confirmed by the Senate, and then used that office to run roughshod over congressionally approved programs. The factual dispute that's going to emerge in discovery is going to be a problem for the administration. Their argument, and you can already see this coming, is going to be something like, oh, Trump was just bragging. He was exaggerating. He didn't really give DOGE that much power. The public statements were just political rhetoric. They're going to try to throw the president under the bus. They're going to try to say that what Trump said publicly doesn't reflect what was actually happening, that the power DOGE exercised was actually much more limited than anyone thought. But here's the thing. If there's a factual dispute about how much power DOGE actually exercised, that means the case goes to trial, because you can't resolve a factual dispute on a motion for summary judgment. If the plaintiffs have evidence, public statements, internal documents, deposition testimony, that DOGE was doing all these things, and the government says no, it wasn't that much. That's a factual dispute for a jury to decide. And that jury is going to hear that Elon Musk himself said DOGE terminated a $2.3 million contract, that DOGE officials themselves said they were shutting down agencies, that the president himself said DOGE had sweeping authority, and then they're going to hear the government's lawyer say, well, actually it wasn't that much. Good luck with that. The discovery fight. The plaintiffs are going to want documents. They're going to want emails. They're going to want internal communications about who had what authority. The administration is going to claim privilege. They're going to try to slow walk production. There will be motions to compel. Judge Chutkan is going to have to decide how much of what the administration wants to hide actually gets produced. The Musk deposition. This is going to be a spectacle. A skilled litigator is going to sit across from Elon Musk and ask him line by line about every public statement he made, every decision he was involved in, every conversation he had about what DOGE could and could not do. And Musk is going to have to answer under oath with the possibility of perjury charges if he lies. This is not a friendly podcast interview. This is a deposition in a federal case. The rules are different. The summary judgment motion. After discovery, both sides will file motions for summary judgment. The government will argue that even taking the plaintiffs' evidence as true, the law doesn't support their claims. The plaintiffs will argue that the evidence shows violations as a matter of law. And Judge Chutkan will decide whether this case goes to trial or gets resolved on the papers. Given what she just ruled on the motion to dismiss, the odds of her granting summary judgment for the government are not high. The political dimension. This case is happening while DOGE is still operating, still making decisions, still firing people and cutting funding. The court proceedings are going to create a cloud over everything DOGE does. Every action they take, there's going to be a question. Is this going to be invalidated later? Is this person even authorized to be doing this? That uncertainty alone is a win for the plaintiffs. Here's the bottom line on everything we just covered. Judge Chutkan just issued an order that allows a lawsuit challenging the entire structure of DOGE to proceed. The lawsuit argues that the person running DOGE was exercising so much executive authority that they should have been confirmed by the Senate under the Appointments Clause, and that even if you ignore the appointments issue, the things DOGE was doing were so far outside any authority they could have been given that they were ultra vires, beyond their powers. The Department of Justice tried to get this case dismissed. Judge Chutkan said no. The Appointments Clause claim survives. The ultra vires claim survives. The case now moves to discovery. That means depositions. That means document exchanges. That means Elon Musk sitting for a deposition under oath, answering questions about exactly what power he had, exactly what decisions he made, exactly who authorized him to do what he did. This is the case the Trump administration feared most. Not because it's the flashiest, not because it's the one that gets the most headlines, but because if the plaintiffs win, everything DOGE did could be invalidated. Every firing, every funding cut, every agency shutdown, all of it undone, because the person doing it never should have been in that position in the first place. We just saw a federal judge rule that Carrie Lake running Voice of America was a similar violation. Everything she did was illegal and improper. Same constitutional principle, different agency. Now it's DOGE's turn. Judge Chutkan is presiding, and Judge Chutkan is not someone who is easily intimidated. She's the judge Trump feared in the election interference case. She's the judge who runs her courtroom with precision and expects the government to follow the law. And she just made it very clear that the government's attempt to kill this case is not going to work. Stay tuned. The discovery fight is coming. The Musk deposition is coming. The summary judgment motions are coming. And we're going to be right here covering every single development as it unfolds.